Hey, folks, welcome. Well, let's see what's going on here. Welcome. Do we have volume? I'm actually not hearing myself, which is unusual. Check. Oh, that's a little better. Okay. So welcome, folks, to today's Law Self Defense Show. Do we have audio? Can you hear me talking? Someone in the chat could respond. That would be absolutely awesome. Check. It looks like maybe, let's see. I'm actually not seeing it myself. Can you folks hear me? All right. Interesting. I'm not hearing it on my own feed. All right. Well, since you folks can hear me, we'll just go ahead and move forward with that. Welcome to today's Law of Self-Defense show. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you very, very, very much. Today, we're going to talk about defense of others. And defense of others really comes in with, I consider to be several distinct flavors, really three distinct flavors that I think ought to be treated differently from each other, even though the black letter of the law is essentially the same for all three scenarios, but there are complexities of the real world, of facts, of uncertainty, of people having different interests that changes how that black letter law, which is really the same in all three scenarios, all three flavors of defense of others, how the application of that law changes as a practical matter and creates legal risks or alleviates legal risks that you might otherwise face. It's a mistake, I think, to treat defense of others as if it's a single homogeneous self-defense or use of force, defense of others, use of force scenario. So before we start, of course, let me mention today's sponsor, which is no other than, oh, come on, folks. Come on. Let's see. That is not the sponsor image I wanted. I made a mistake, of course. Let's see. Here we go. That's much more like it. Today's sponsor, the sponsor of today's Law of Self-Defense content, is no other than Law of Self-Defense ourselves. So, folks, we have a book. We've been moving this book for almost 30 years now. Law of Self-Defense Principles. This is the most recent edition of this book. It's really the fourth edition now. The first came out in 1997. That was quite some time ago. And we make this book available to all of you for free. It is a real physical book. It's not some kind of grift. It's not just a 6-page PDF download or something. About 200 pages long, I think a little more than that. You can find it on Amazon, and I encourage you to find it on Amazon. There's lots of reviews there, over 1,000 reviews, solid 5-star rated book. You don't have to just take my word for it. I'm sure there's people watching this show right now who can put in the comments what they think of the book. Totally fine. But don't buy it on Amazon. If you buy it on Amazon, they charge you, I believe it's $25 plus shipping and handling. We will eat the $25 cost of the book. We do ask you to still cover the shipping and handling. So there is that. But the book itself is free. So if you'd like to get a copy of this book for free, folks, and listen, if you're not willing to pay shipping and handling on a free book to learn self-defense law, I got to be honest, it's hard for me to be too sympathetic when you call my office and say, yeah, I'm facing a 20-year felony charge for making someone aware I had a gun on my person. Anything you can do for me? That's not a great place to be, folks. You can avoid that kind of dilemma with a free book. And it's very easy to read, folks, very accessible. That's the biggest compliment we get on this book, is that it's easy for non-lawyers to understand. Most people read it in 3 or 4 hours, and it's free. And you can get this at lawofselfdefense.com/free book. Easy enough to remember. Okay, folks, with that sponsorship message out of the way, let's dive into what we're talking about today, which is defense of others. Now, this was prompted to the forefront of my attention by the recent shooting event in Indiana, the mall shooting event, where the defender shot Elisha Dickens, shot and killed an active shooter in the mall within seconds. I believe it's 15 seconds of the active shooter having begun to murder innocent people. He did, in fact, murder several innocent people before he was neutralized by Dickens. But Dickens was on the ball and engaged that active shooter with pistol fire very quickly, within a few seconds. Maybe that's the within 15 seconds. At least beginning at approximately 40 yards. I'm told that he was closing distance on the active shooter as he was shooting, so some of the shots presumably were fired closer. But nevertheless, these are real handgun distances, folks. 40 yards, 30 yards, 20 yards. That's shooting with a handgun. It's not that easy to do. Especially, it's not that easy to do and get 8 out of 10 solid hits, which is reported to be the number of hits of the number of shots fired. 8 out of 10. That's pretty darn good, folks. So great job there by Elisha Dickens. Elisha, if you'd like a free copy of my book, I'll send you the hard copy, which anybody can get. This one's not free, folks. They're too expensive to manufacture, but they're beautiful books. They make great gifts. You can get these at lawselfdefense.com/gethard. Get Hard. Same book as the softcover, but in a beautiful hardcover format. Elisha, if you'd like a free copy of the book, have someone reach out to me. I'll be happy to send it to you, obviously. But what we were dealing there with in the mall was really a defense of others situation, right? Elijah, I would suggest, could have safely fled the scene. He has no legal duty to protect anybody else. He could have fled for his own safety, and there would have been no legal repercussions, no real moral repercussions. I mean, no one's under a legal duty to get into a gunfight, especially on behalf of other people. So kudos to him for having the guts and moral fortitude to actually do that. Because remember, folks, when you go into a gunfight, there's no magic pixie dust that says you win. It's a fatal encounter. Someone's going to die. It could be you. It didn't have to be the active shooter. Especially when the active shooter has a long gun, you've got a handgun. That's not a great matchup, folks. My 13-year-old daughter, when I introduced her to the AR, could hit heads on an IDPA target at 100 yards all day long with an AR with a dot on it. A little kid. So certainly a grown-ass adult active shooter is going to have at least that level of capability with a long gun. So it's a very lopsided encounter if you're armed with a handgun and the other fellow's got a long gun. That's not a reason not to do it. I don't tell people what to do, but that's just the tactical reality of the situation. And anytime you go into a fight, remember, you're running two risks you were not running a moment before: a risk of losing the fight. In this case, it's a gunfight, so the risk of losing is death, and or a risk of going to jail for the rest of your life if other people decide that your use of force was outside the legal boundaries. Remember, it's not up to you. It's not your judgment that determines your legal outcome. It's the judgment of other people, of police, of prosecutors, of judges, of jurors. They decide your legal fate. And by the way, that decision could be guilty and life in prison without possibility of early release, even if in reality you were innocent. What you did was perfectly lawful. Innocent people go to prison, folks. If I have to put you in front of a jury, there's a 10% chance you get convicted no matter how innocent you are. So these are the risks you're running when you go hands-on or guns on in that confrontation. Risk of death, risk of going to jail for the rest of your life that you don't have to incur if you run away, right? Elisha didn't run away. He saved a lot of people's lives by intervening in that event when he didn't have to. So this was a defense of other situation because he did not have to use force to defend himself. He was using force to defend other people. So because this was a defense of other situation, I thought it worthwhile covering again. I've done this before, but we recover topics from time to time. There's a lot of use of force, law, and legal doctrine to remember, folks. So we kind of recycle content as seems appropriate. And this seems an appropriate time to recover the defense of other legal paradigms. Let's see. Well, it looks like the Law Self-Defense members stream is not working. Sorry, folks. You can go to YouTube to watch it. And let me see if we have it working on Rumble. Sorry for the pause, folks. It does not look like it's working on Rumble either. So if you want to watch today's live show live, I guess YouTube is it. For the Law Self-Defense members, we will, of course, be uploading the recording of today's show onto the members dashboard. I'm sorry, the members blog site. And by the way, we have a new feature for Law Self-Defense members. We finally have arranged to have transcripts done of these shows by an actual human being who's an English speaker. So we've had transcripts before. They were electronically done or they were done by contractors, and I wasn't happy with the quality. But now we have something, I won't say it's perfect, but it's much better. It's sufficient. So I won't claim the transcripts of the shows are 100% accurate. I don't have time to ensure that, but they're 95% there. And a lot of people I know prefer to read. They can read much more quickly than they can watch an hour or 2 hour long video. So we've begun providing transcripts on the Law of Self-Defense blog, where we share these the videos of these shows in a playback fashion. But those Law of Self-Defense blog posts are for Law of Self-Defense members. So they will be locked down. You have to be a Law of Self-Defense member. You have to have signed into your account, and then you'll be able to access those videos with those transcripts included. I will say the transcripts, because we do have to get them transcribed, tend to come about one business day after the live show is posted up. So they're not same day. Sorry, folks, nothing I can do much about that. All right, so back to today's actual content. Defense of others. Let me take a sip of my coffee. And last thing before we jump in, folks, since everyone is watching this on YouTube, because my other delivery formats, don't appear to be working. A couple of things. One is I see we have at least a couple hundred people watching, and we have fewer than 100 likes. So if the likes don't go up substantially, this program ends. That's just the way it is. I'm here for free, folks. I know some kind viewers send in the occasional super chat, and that's much appreciated. But I can assure you the super chats don't cover the value of my time. So I ask that you bump up the likes. Thank you very much. I see they're going up already. If that subscribe button on your screen watching YouTube, if that subscribe button is red, WTF, folks. This is free content. If you're here, I presume it's because you like it. Hit that damn subscribe button. Turn it gray. Hit the bell, so maybe you'll get notifications. And also, if you could please put a comment into the chat, even if it's just your city and state, or just your state, or just say hello, whatever. That helps fool the YouTube algorithm into spreading our content more broadly. Most of you know that Ricardo Law's Nick's channel has been suspended for who knows how long on YouTube, hopefully not too long. That's the way these platforms work, folks. They're bullies. So anything we can do to leverage their algorithms to our advantage, I would ask that you help me do, and commenting is one of the best ways to do that. The very best way is that subscribe button, folks. The more subscribers we get, the more favorably we're treated by YouTube, and the more broadly we can get our message out. So I would ask, please hit that subscribe button. Wow, Jeremy Hayward just dropped a huge super chat. Thank you. Actually, that's worth 5. I got to make that work more quickly, but thank you very much, Jeremy. That's much appreciated. All right, so let's dive into defense of others. So you've heard me talk about self-defense as a legal justification. And of course, self-defense is a physical act, but self-defense is also a legal defense that your attorney raises on your behalf when you're charged with some use of force crime. That crime, if you've killed somebody, might be murder or manslaughter. If you've injured somebody with a weapon, it might be aggravated battery. If you've merely frightened someone with a weapon, put someone in imminent fear of deadly force harm, even though you never caused them a scratch, that could be aggravated assault with a deadly weapon. Aggravated assault meaning you've put them in fear of deadly force harm. And by the way, folks, aggravated assault with a weapon is good for 10 to 20 years in prison. It's a very, very serious criminal offense. Or it could be simple battery if you've caused someone injury or made contact of a non-deadly nature, you've shoved somebody. It could be simple assault if you've merely put someone in fear of non-deadly contact. Or you could have done both, right? You could have run up, frightened them into contact, and then actually contacted them, and then we have classic assault and battery. So those are all typical use of force charges. There could also be brandishing, menacing, other typically lower level, usually misdemeanor type of offenses. And to all these use of force charges, if you're charged with one of those crimes, your lawyer would, in a self-defense situation, raise the legal defense of self-defense. The legal defense of self-defense is a justification defense, also characterized historically in legal textbooks as a defense of confession and avoidance. So unlike an alibi defense where you're saying it wasn't me, I wasn't there, I was at my mama's house having dinner, I had nothing to do with this, denying any involvement with the underlying physical acts that make up the criminal charge, the shooting or whatever it might have been. Unlike an alibi defense where you're saying you didn't do it, in self-defense, you're saying the opposite of that. You're saying I did it. I shot that guy. I killed him with my gun and my bullet. He's dead because of me. No ambiguity about that. But I did it in accordance with the legal justification of self-defense. So you're confessing to the underlying physical conduct, but you're seeking to avoid criminal liability on the basis of justification. So confession and avoidance. You're not confessing to a crime. You're confessing to the underlying conduct. Because if what you did was lawful self-defense, it's simply not a crime, right? But that's the confession and avoidance. If you deny it was you and you simultaneously try to raise the legal defense of self-defense, first of all, the judge could deny the defense because it's inherently incoherent. You can't say it wasn't me and also I did it in self-defense, right? That just doesn't make any sense. Even where a judge allows you to make those technically inconsistent defenses, and sometimes they do, if the judge is kind of a legal technician, he'll allow that. But I can tell you, juries don't buy it. If you've shot and killed someone, they want to know why that had to happen if you're in front of a jury. That guy's dead. Maybe he needed to be dead, but they want to know that. They don't want to hear some bullshit about logically inconsistent defenses that they can cherry pick from. That's not going to fly. And it's certainly not going to fly with a judge if you're doing a bench trial and the judge is playing the role of the jury. So although technically speaking, legally inconsistent defenses may be permitted in a self-defense scenario, they just don't fly in court. So they don't exist. So if you're raising self-defense and you want that to be an effective defense, you're going to concede the underlying conduct and try to justify that conduct as self-defense. So keep in mind what this is doing for the prosecution, because the prosecution is very much aware of this. Normally, if you were raising, say, an alibi defense, the prosecution would have to prove the elements of the criminal charge. If it's murder, that you intentionally killed another person, right? They don't really have to do that in a self-defense case. I mean, they do technically, but you've given them everything they need in order to accomplish that because you've conceded it was you who fired the shot. So you're basically giving the prosecution the criminal charge. Now what the prosecution has to overcome is your legal defense of self-defense. That defense they have to disprove beyond a reasonable doubt. You've basically given them the elements of the crime, but now they have to disprove your claim of self-defense beyond a reasonable doubt. And how do they do that? Well, they do that. They disprove self-defense beyond a reasonable doubt by attacking any one of the required elements of your claim of self-defense. Because those elements are cumulative. The required elements of self-defense, the legal defense of self-defense are all required. That's why they're required elements. And if any one of those elements is missing, whatever you did, it was not self-defense because you're missing a required element. Make sense? The good news is that there aren't 500 elements of self-defense. There aren't 50 elements of self-defense. There's only 5, only up to 5. Often there's only 4. Sometimes there's fewer than 4. There are circumstances in which some of the elements may be legally presumed to be present, like in a defensive home situation, for example. Most states, one of those 5 elements is the element of avoidance. I'll just recite the 5 elements for you. They are innocence, imminence, proportionality, avoidance, and reasonableness. One of those 5 elements is avoidance. Avoidance has to do with whether or not there's a legal duty to retreat before you can use deadly force in self-defense. There's only 11 states that impose that legal duty to retreat. So there are 11 states that do impose all 5 elements, just as a general of standard policy, a matter of standard policy in those states. But 39 states don't impose the element of avoidance in otherwise lawful cases of self-defense. So in those 39 states, there's really only 4 elements you have to worry about: innocence, eminence, proportionality, and reasonableness. But you do whichever ones are required, whether it's 5 or 4 or 3 or 2, whichever elements are required based on the facts and law in your case, they are required. So when the prosecution gets that investigative report from the detectives who are, investigating your use of force, what they're looking for, if they're smart, what they're looking for in that investigative report is one or more of those elements that they believe are vulnerable to attack, by which I mean vulnerable to disproof beyond a reasonable doubt. Because the prosecution knows, hey, if it's going to be a self-defense case, you've conceded the criminal charge. Now what he has, so he's got that. That's in his pocket. Now what he has to do is overcome your legal defense of self-defense, and he does that by disproving any one or more, but any one of the required elements of self-defense beyond a reasonable doubt. If he does that, your legal defense of self-defense collapses entirely. It doesn't exist anymore. And all that's left is your concession of the criminal charge. That's a walk-away conviction for a prosecutor. So believe me, a prosecutor knows when he's facing a self-defense case, what he's looking for are those 5 elements to see if any of them are vulnerable. The same 5 elements apply in defense of others. Self-defense, using force to defend yourself from harm, and defense of others, using force to defend others from harm in the absence of a threat to yourself. So a pure defense of others situation, it's the same elements, folks. It's the same elements. If you look up the defense of others law in your state, states tend to approach this one of 2 ways. Either they'll have a self-defense statute and then a separate defense of others statute, but if you read them, the elements are the same. Or they'll have one single statute that simply incorporates the third person pronoun, not the progressive fascist pronouns. Just it'll say something to the effect of a person is privileged to use force in defense of themselves, that's self-defense, or others, that's defense of others, if they meet the following conditions. And those conditions are, of course, the elements of self-defense. So it's the same. Black letter law applies to defense of others as it does to self-defense. There's a couple ways of thinking about the defense of others situation. One is that you are privileged to use force on behalf of another person to the same extent you would be privileged to use force in your own defense if you were in their situation. So if you were placed in their shoes, facing what they were facing under the same circumstances, whatever force you would be privileged to use in defense of yourself, well, you're privileged to use in defense of them in the defense of other scenario. Or alternatively, you could think of it in terms of you're privileged to use force in defense of them to the same extent they would be privileged to use force in their own defense in that circumstance. Now, that's all conditional, right? Because just like you have to meet conditions, the 5 elements, however many elements are required in that particular case, to be justified in using force in your own defense, they would also have to meet those conditions, right? If they fail to meet any of those conditions, if they fail to meet innocence, eminence, proportionality, avoidance, or reasonableness, well, they wouldn't have a privilege to use force in their own defense, and therefore you would not have a privilege to use force on their behalf. But the same conditions apply. So the black letter law is the same for all practical purposes. Between the law is the same for defense of self and defense of others. It really doesn't change. But what does change? Why are they not, for practical purposes, exactly the same situations? And what changes is not the law, really, but the world, the real world, the facts, the uncertainty about the facts, the ambiguity that can be inherent to a defense of other situation creates additional risk in a defense of other scenario that you're not incurring in a self-defense scenario. Now, how much risk you have is a function of which flavor of defense of others we're dealing with. Okay? And I really put defense of others in one of 3 buckets. The first bucket is defense of people you know. And by that, I mean defense of family, defense of friends, not just acquaintances, but close friends, people you have a real relationship with, defense of colleagues. I don't mean just people you work with. Again, I mean people you have a long-standing relationship with. You know these people. You know them well. not superficially, and they're certainly not strangers to you. So defense of people you know, that's the first bucket of defense of others. The second bucket of defense of others is defense of strangers. These are people you have no relationship with. You don't know them. You turn a corner and you see a fight among strangers and you decide to intervene. That's the really high risk scenario from a legal perspective. All of these are fights, right? So you have all the usual risks of death and possibly spending the rest of your life in prison. But defense of others adds a third dimension of risk, which is potential ambiguity about the situation. And the highest level of ambiguity comes in that second flavor of defense of others, the defense of strangers scenario. Then we have a third bucket where it's still defense of strangers, but it's lacking the usual ambiguity of defense of strangers, and that's defense in an active shooter situation, which is what we had in Indiana. Okay, so again, to recap, we have defense of people we know. That's the first flavor of defense of others. The second flavor is defense of strangers. And the third flavor is defense of others in an active shooter type situation. And now I'll explain to you how they differ, what the implications are. So I'll start with the second flavor. The biggest risk we have is defense of strangers we don't know outside the active shooter situation. So you turn a corner, you see a couple people fighting. One of them looks like they're losing. They look like they're the innocent person who's losing, and you decide to intervene to protect that innocent person from what appears to be the unlawful aggression being used on them. This is not uncommon. I mean, we all see these news reports, often with bystanders just standing around, where some victim's getting beat. Maybe it's a woman getting beat by some guy in a subway, and all the bystanders are standing around, and a lot of us will say, I can't believe all those people just stood around and didn't do anything. Well, they might not have done anything because they're cowards. That's possible. But they might not have done anything because they're prudent, because there is a lot of risk in intervening in the physical confrontations of strangers. First of all, we have potentially what's called the alter ego problem, or a reasonableness problem. So the general standard, remember, one of the elements of self-defense is reasonableness. Everything which has two components. First, subjective reasonableness. You had a genuine good faith belief that you were justified in using that force in defense of self or defense of others. So that's subjective reasonableness. That's one half of the reasonableness coin. The other half is objective reasonableness, that a hypothetical, reasonable, and prudent person would have shared your subjective belief. So your subjective belief can't be irrational. It has to be a subjective belief that would have been shared by a hypothetical, reasonable person. And this is what's applied in the standard of self-defense, which means that you're allowed to be mistaken. So, for example, someone approaches you out of an alley and points what appears to be a real gun at you and says, "Give me your wallet." You're apparently the victim of an armed robbery. You decide to step off the X, draw your own pistol. You neutralize that threat, resulting in that person's death. And then it turns out their apparently real gun was actually just a realistic looking toy. Now, you shot that person because you had a subjective, genuine, good faith belief that you were being threatened with deadly force harm. In fact, you were mistaken, right? That toy does not have the means to cause you death or serious bodily injury. You were wrong about being threatened with deadly force. Does that mean you lose self-defense? No, because what the law requires is that subjective good faith belief which you had, and that the belief be reasonable, not correct. You don't have to be correct about the threat or apparent threat you're defending yourself against. Your perception of that threat, your subjective perception, has to be reasonable. It can be mistaken, and that's fine, so long as it's a reasonable mistake. In other words, a hypothetical, reasonable, and prudent person seeing that same toy gun would also have concluded, under the circumstances, the lighting, the rapidity of the events, would have shared your subjective belief that it was real, right? And of course, there are guns out there, that toy guns, airsoft guns that look very much like real guns, easily mistaken for a real gun. The point is, you don't have to be right about it being a deadly force threat. it's not the reality of the threat that matters. It's the reasonable appearance of the threat. So when we're talking about defense of others, the standard might be less forgiving. And historically, it was a lot less forgiving. So historically, many states would apply what's called the alter ego standard to defense of others. So you're stepping in to defend some other person. And again, typically we're talking about a stranger context here. And you see them being threatened with what appears to be a gun. To your eye, from your vantage point, your perspective, that looks like a real gun being pointed at them. From their perspective, however, that person you're defending, they know it's a toy. Okay, maybe they know it's a toy because it's theirs and it was taken from them. Who knows? But for whatever reason, they know it's a toy. You mistakenly but reasonably perceive it as a real gun. But they know it's not a real gun. They know they're not being threatened with deadly force. Well, under the alter ego standard for defense of others, your legal position is their legal position. Exactly. You are standing in their legal shoes. So because they actually know it's not a deadly force threat, they would not be privileged to use deadly force in self-defense. And under the alter ego standard, if they would not be privileged to use force in deadly self-defense, you're not privileged to use force in self-defense, deadly force in self-defense. Because your privilege to use force on their behalf extends only as far as their privilege. And the law under the alter ego standard does not care how reasonable your mistake was. Reasonableness does not come into it. Under the alter ego standard, you're only privileged to use force as far as they would have been, giving what they believe to be true. So you might reasonably perceive, mistakenly, but reasonably perceive a deadly force threat and then seek to neutralize it, only to discover later that they did not share your perception. And under the alter ego standard, that means they would not have had a privilege to use deadly force in self-defense, and you don't have a privilege to use deadly force in defense of them on their behalf. Now, the good news is that the alter ego standard was historically prevalent decades ago, but over time, the states have moved away from it. The states have moved away from the alter ego standard to adopt a standard that's more clearly reflective of the self-defense standard, the purely reasonable standard. So under the purely reasonable standard, it doesn't matter what that person you're defending actually knew. It's not the alter ego standard. You're not standing in their legal shoes. You're allowed to conduct yourself on the basis of your own reasonable perceptions. There are a couple of states, I believe South Carolina is one, for example, where they have not addressed this issue of law in many, many, many years, or at least they hadn't the last time I checked, which was within the last year or two. That could always change, of course, because there's always new self-defense appellate court decisions. So the South Carolina, for example, may have clarified this since the last time I looked. But where you have a state where the law on this, the court decisions, the appellate court decisions, the case law on this question is very old, it may still reflect the old standard of alter ego. Now, and the last time I checked in South Carolina, that was the case. Now, it would be my expectation that if they get a new defense of other case where in the appellate courts where this came up, that they would adopt the new standard, the more modern standard. But the existing case law, last time I looked, was not the modern standard. It was still the alter ego standard, not the reasonable standard. So fair caution. But in most states, alter ego is gone. They've done away with it. And it's simply the same reasonable mistakes are okay standard as would be applied to self-defense. This alter ego risk is particularly substantial when we're talking about defense of strangers, because when we're talking about defense of strangers, those strangers may not share your interest in yourself. What I mean by that is we've all heard about cases of domestic violence where someone calls the police because one spouse is beating up another spouse, and the police show up and they go to arrest the person they believe to be the aggressor spouse, and the victim spouse turns on the police. Right? We've all heard of this happening. If you haven't, and you know any police officers, just ask them. Any police officer who's ever responded to a domestic, which means all of them, they've all responded to domestics, has seen this happen at one time or another. because the victim, the domestic victim's interest in their abuser is maybe substantial. And they may not want that abuser to go to jail, despite the beating, for a variety of reasons. So they'll attack the police officers to keep their abuser from being taken away to prison, even though they were the actual victim of a physical attack by that abuser. Now, imagine if it wasn't a police officer, it was you intervening. You see some woman getting attacked and you decide to intervene. You shoot her attacker. And let's say it under circumstances that appear to you to be justified, reasonably appear to you to be justified. But then when the cops show up, that woman who you rescued tells the police that it wasn't her abuser that was the problem. She was never really scared of him. Sure, they have a tumultuous relationship, but that's the nature of their relationship. She loves him. She wasn't really scared until you showed up and started waving a gun around. You were the problem. What if she goes further than that and just outright lies about what happened to make you look like an unlawful, deadly force aggressor in that confrontation? And she's the only witness besides you. If the person you rescued is prepared to tell the police, the prosecutors, the judge, the jury that you were the problem, you think you're at legal risk there? Even if they're lying? Yeah, you're at a lot of legal risk, folks. Remember, if I have to put you in front of the jury and you're the most innocent person in the world, there's a 10% chance you're getting convicted. That's just noise in the system. Innocent people get convicted. If I have to do that, and there's a woman taking the witness stand, the sobbing wife and mother of these orphan children because you killed that guy, she says, unnecessarily, your chances of conviction didn't go down, folks. They went up substantially. So that's part of the defense of strangers scenario that's very risky. That person you rescued may not have your interest at heart. Another risk, of course, is pure ambiguity risk. So we've probably all heard about scenarios. Well, I'll just share a hypothetical. You turn a corner, you see a woman, she's being grabbed by two grungy looking guys, and she's screaming for help. Help me. These guys are kidnapping me. They're going to rape me. Somebody help me. Well, kidnapping and rape are deadly force acts of aggression. She would be privileged to use deadly force in her own defense if she was being kidnapped and raped. So under the general doctrine of defense of others, you're privileged to use deadly force on her behalf to prevent her from being kidnapped and raped. And you do that. You whip out your gun. You say, let that woman go. Except it turns out that her kidnappers are actually just two undercover law enforcement drug agents making a perfectly lawful arrest. Now what? Now you've just pointed a gun at two officers in the course of their duties. And they didn't look like cops because they're undercover. But nevertheless, they were cops. That doesn't look good, folks. Now, what can you do? You can argue that you reasonably perceive them as kidnappers. Based on the information you had, the woman screaming she was being kidnapped, the officer's non-officer-like appearance, that would be your legal defense. That's the defense I would raise. And maybe it'll work. Maybe it won't. But of course, there's also an additional risk, and that is, what do cops tend to do when they have guns pointed at them? They tend to point guns back, and then loud noises start happening. And this, because you turned a corner and saw a fight, you didn't really know what was going on, right? Now, I'm not telling you not to intervene in defense of stranger scenarios. That's your call. I don't tell people what to do. But if you're going to intervene, I want you to do it in an informed way, understanding what the risks actually are. So that's defense of others. That's the super high risk scenario in defense of others, when you're coming to the defense of people who are strangers to you. The first flavor of defense of others I mentioned is defense of others who you know, family, friends, colleagues, people you know well. The risk there is much reduced because of the fact that you know them. You know whether or not they were likely to be themselves the initial aggressor in the fight, or likely themselves to be unreasonably perceiving a threat, or likely themselves to be the kind of people who would be subject to a lawful arrest for drugs, right? Hopefully, most of our family and friends and colleagues don't fall into any of those categories. So if we see those people getting attacked, the apparent victims of a unlawful use of force, there's less ambiguity than in the case of strangers. Plus, because you know these people, and presumably they know you too, your interests are aligned. They're not likely to lie to the police, to the prosecutors, to the judge, to the jury, to get you convicted in order to save the person attacking them. They have an interest in your welfare, right? They're not going to lie to get you convicted. So the defense of people you know situation has much less of that risk that I just talked about at length regarding defense of strangers. And then we have the third flavor of defense of others, which is also a variation of defense of strangers, and that's the active shooter situation. So you're in Indiana, you're in a mall, guy comes out with an AR and starts potting customers in the mall. That is distinguishable from the general defense of strangers scenario because it lacks the ambiguity of the general defense of stranger scenario. You turn a corner, you see two people in a fight, you don't really know what's going on. There's a lot of ambiguity there. There's a lot of risk. There's a lot of maybe departure of self-interest there. But you're walking through a mall and you see a guy with an AR start shooting people dead. There's no ambiguity there, folks. You know who the bad guy is. And you know that those people, if you act and keep him from shooting any more people, you know those people saved are not going to testify against you for the benefit of the active shooter. So we don't have that domestic dynamic going on either. Now, that doesn't mean there's much reduced legal risk. I would suggest there's actually zero legal risk in coming to the defense of others in an active shooter scenario. So long as, one, it's in fact an active shooter scenario. You're not unreasonably perceiving somehow something as an active shooter scenario when it's not. But one, it's actually an active shooter scenario. And two, your response is non-reckless. Okay, so if you were in that active shooter scenario and you just whipped out your handgun and kind of blindly did a mag dump in the general direction of the active shooter and managed to hit a bunch of innocent people, and your conduct could be characterized as reckless, that you were not engaging that active shooter in a reasonable manner and using the sights, for example, under circumstances in which using the sights was realistically possible. Well, if you're acting recklessly, recklessness is by definition not reasonable. And reasonableness is an element of self-defense and defense of others. So you have to be acting reasonably. And recklessness would disqualify that. Now, how do you know whether someone's acting recklessly? Well, one way you know is simply by looking at the conduct itself. There's a legal expression, res ipsa loquitur, Latin, and it means the thing stands for itself. How do we know, for example, that this Elisha Dickens shooter in Indiana in the Greenwood Mall, that his use of force against that active shooter was not reckless? Well, the thing speaks for itself. He fired 10 rounds and hit 8 times at considerable distance. That's not reckless, folks. That's damn good shooting. That's controlled, disciplined shooting. Now, he did miss twice, but still, under those facts, that is remarkably good shooting. If he had missed all 10 times, hitting innocent bystanders, might that have looked reckless? Maybe. I mean, you might say there was nothing else he could do under the circumstances. At the very least, maybe he was distracting the active shooter. But clearly, it's distinguishable from 8 out of 10 hits, right? So you have to have acted non-recklessly. But if it was actually an active shooter event and your use of force was not reckless, your legal risk in engaging that active shooter is effectively zero. And really, that's true even if you hit innocent bystanders, for reasons we talked about in yesterday's show when we talked about unintentionally hitting innocent bystanders in the use of force event. So the legal risk is really minimal. That doesn't mean there's no risk, of course. As we talked about already, there's enormous physical risk. There's risk of dying in the gunfight. So those are the 3 broad flavors of defense of others and how they're distinguishable. Not so much on the law. The black letter of the law really applies the same to all of them. Really is not that much different than defense of self. But because the facts, the circumstances vary between defense of people you know, defense of people who are strangers to you, generally speaking, and then defense of strangers in an active shooter type of scenario. Those are three different flavors of defense of others with three different levels of ambiguity, uncertainty, and factual risk that may alter your decisions about engaging in defense of others. So I would suggest it's worth thinking about, and worth thinking about today before you have to make the decision, that it matters whether when you come to the defense of others, it is the defense of someone you know, a family member, friend, colleague, or coming to the abrupt defense of someone who's a complete stranger to you, or coming to the defense of others in an active shooter type of situation. Fair enough? Okay. So let me take a look at the, hold on one second, folks. Let me see if I can get somebody's attention here. Well, you shout Emily 3 times and it doesn't work. It's not like Beetlejuice, 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 unfortunately. The video today was not working on the Law Self-Defense members dashboard, the live field. Let me see if there's any questions there that need to be raised. So Donnie, who's a longtime Law Self-Defense member, writes, normally there's more than one defense to a criminal charge that has a use of force as an essential element of the offense charged. There can be more than one legal defense, but here I can't cover every legal defense in every show. But there could, for example, theoretically be a self-defense. One second. All right. So there can be multiple defenses. I mean, you could be in a situation where you have the justification, the legal justification of defense of self. You're defending yourself against the active shooter, and defense of others, that there's other people you're also using force in defense of, and maybe even defense of property if you're in Texas. And there's a defense of property provision there, deadly force in defense of property provision. Yeah, you could have layered defenses for sure. But we tend to focus on one at a time just for purposes of simplicity and facilitating the educational dynamic here. Dale writes, hi, Andrew. Dale here from Illinois. I always enjoy listening to your program. It has many helpful tips for any concealed carrier. Thank you. He also tells me the show's not working. Thank you, Dale. Yes, I know. So it looks like folks hopped over to YouTube. And that's all I have on the member channel. Let me take a look now at our super chats. Let's see if I remember how to pull this up there. Click that, click this, click that, and we do. Shut up, I can cook. That's the name of the contributor. Contributed $10 super chat. Thank you very much. Says, showing support to a very wise and honorable man. I can always tell when I'm dealing with someone who has not met my ex-wife. Let's see. Showing support to a very wise and honorable man. Pandemic seems to have told people it is a violence-free for all. Jack Bauer, we need you. Folks, it's a dangerous world out there, and it's not getting safer anytime soon. I mean, I don't tell people what to do. I'm not going to tell anybody to carry a gun, especially if they're not comfortable carrying a gun. I can tell you I carry a gun. I do it every day, have my entire adult life. And I'm not likely to stop anytime soon. Switch 1947, $10 super chat. Thank you very much. Writes, that's the advantage of OC. So pepper spray, I don't have to worry about an assault with a deadly weapon charge if I pull my shirt up in a conflict. Yeah, I urge everyone, folks. I mean, as I mentioned, I carry a gun every day for personal protection. And every day I carry my gun, I'm also carrying OC, pepper spray. Because if you look at the Department of Justice, FBI statistics, you're 5 times more likely to be involved in a non-deadly use of force event against which your gun is not a lawful response than you are to a deadly force confrontation in which your gun might be appropriate. But you're 5 times more likely to be in a situation where going to the gun is not the legally correct answer to the problem. And then you need some non-deadly means of defending yourself. OC is one option. Another option is You might have bare hand fighting skills, BJJ skills, for example. By the way, for those of you who have been telling me for years that I need to start BJJ, starting. Just went to did a walkthrough in a BJJ academy today. I should be starting this week or next week. So there we go, a new adventure. It may be a taser, it may be whatever. I don't care what it is, but you ought to have something other than a deadly force self-defense toolbox. I can tell you a lot of the cases I work on, a lot of the cases I consult on are cases where it's a normal law-abiding person, never been in trouble with the law a day in their lives, has a concealed carry permit, carries a gun with them. Great. And they got scared by someone who was aggressive and they pulled their gun under circumstances where it's questionable whether going to the gun was legally appropriate. And now they're facing an aggravated assault with a weapon charge and looking at a 10 to 20 year felony prison sentence. If they'd had OC and gone to that, there would have been no charge in 99.9% of these cases. But because they went to the gun, everything escalates very abruptly. Every problem is not a nail, folks, and every solution is not a hammer. Jeremy Habor, $50 super chat. As I mentioned earlier, writes to help fill the tip jar. Thank you very much, Jeremy. I'm going to send that $50 right to the BJJ Academy to get me started. Shut Up, I Can Cook. And again, another $10. Helping also to fill the tip jar. Yay. That's awesome. Thank you very much, Shut Up, I Can Cook. Rock Steady, $20 super chat. Take the like and call this a discount on services. Love the informative content. Thank you so much, Rocksteady. Again, folks, if you're watching this on YouTube and that subscribe button is red, you're doing it wrong. Smash that subscribe button until you knock it unconscious. That's when it turns gray. You know you've done it right. Hit the bell so you get notifications. Hit that like, thumbs up. Presumably you're here because you like the content. You might as well tell YouTube that you do. And if you could please put a comment in the chat, even if it's just your city and state, that helps fool the YouTube algorithm into sharing our content more broadly. So thanks for all of that. Joseph DiMartino, a Law Self-Defense member who came over here from the member dashboard, I presume, writes, $10 super chat. Thank you, Joseph. Writes, not only did Eli hit with 8 out of 10 shots, he correctly judged where his target was, what was between him and his target, and what was behind him, since he didn't hit anything he wasn't aiming at. Well, listen, I think Elisha did a fantastic job. There were 2 misses. And really, there are no misses ever, right? Because the shooter might miss his intended target. The bullet doesn't miss. The bullet keeps going until something stops it. So I'm sure if Elisha could call back those 2 missed rounds, he would and make them hits, right? We all would. I'm not trying to be critical of Elisha here. It was an amazing shooting performance. But anytime a gun comes into play, a miss is possible. Even if you're doing everything responsibly, reasonably, non-recklessly, a round can miss. Misses happen, especially under stress. Rounds can overpenetrate and continue on. These things can happen. Guns are inherently dangerous objects for that reason, folks. All right. So as I was doing that, I see more super chats were coming in. So I need to refresh this page. Looks like just a couple. Switch 1947, again, $10 super chat. Thank you very much. Yes, folks, if you'd like me to answer your questions or address your comments, they have to be in super chat form. There's too much stuff going on in the chat for me to read it while I'm in real time doing all this. So the only way I can do this effectively is to address the super chat ones. And they don't have to be a lot, folks. I don't know what the minimum is, but I see $2 super chats from time to time. So that is sufficient to get yourself on the scoreboard, at least for the time being. So I'll refresh that again, open this up, and we have, Switch 1947, again, another $10 super chat. OC, open carry better than concealed carry. Don't risk assault with a deadly weapon charge. Almost certainly true. Eric, $9.99 supercharge. Thank you, Eric. Thank you. Says Andrew, hope all is well, buddy. Is that an Eric I know? I don't know. It could be. But thank you for the kind wishes. I much appreciate that. Aquamarin, Switzerland, CHF. I guess they used the franc, right? Switzerland. Yeah, when I went through Switzerland years ago on a motorcycle trip, unlike the rest of Europe, which was using the euro, and which didn't have customs checks at the borders. When I went through Switzerland, there was a customs check. They didn't stop me, thank goodness. They just waved me through. Not because I'm not worried because I had contraband, just the inconvenience. There was another motorcyclist that had pulled over, and they were completely unloading his bike. So I didn't have to go through that. But I did have to switch to Swiss francs, and Switzerland was beautiful. The Alps, riding through the Alps was the only riding I've done that's comparable to the Rocky Mountains in Colorado. Just absolutely gorgeous. So he says, from the tip jar from Switzerland to sorry, my apologies, to Swiss francs. Thank you very much, Aquamarin. Much appreciated. All right, folks. Well, it looks like we got through everything. And miraculously, again, I'm once more right at the top of the hour. So one more mention of our sponsor of today's content, which is, again, us. We're sponsoring our own content today in the form of, where the heck is it? Here it is. Our own book, The Law of Self-Defense Principles. Will make this book a real physical book, folks. We have to mail it to you. That's why there's a shipping and handling charge. We have to mail it to you. It's not just some grifty PDF download. A real physical book, a couple hundred pages, very well reviewed on Amazon, if you look for it on Amazon. But Amazon will charge you $25 for the book, plus shipping and handling. We'll eat the cost of the book, send it to you for free. Ask only that you cover the cost of getting the book to you at lawofselfdefense.com/free book. And with that done, I think I'll just remind everybody, as always, that if you carry a gun, so you're hard to kill. That's why I carry a gun every day, have my entire adult life. I carry a gun, so I'm hard to kill. And my family is hard to kill. Well, if that's why you carry a gun, then you also owe it to yourself and your family to make sure you know the law so that you're hard to convict. All right, folks, you may want to join me for tomorrow's show coming up tomorrow, obviously. And that show is going to be on shooting the fleeing aggressor, firing shots at the aggressor as he's running or driving away. Can that ever be lawful? The answer is yes, it could be lawful. But the circumstances under which it's lawful are pretty damn narrow. So that's what we'll talk about tomorrow. Shooting the fleeing aggressor. Can that ever be normal? You can find that right here back at YouTube, maybe Rumble, and hopefully the Law of Self-Defense member page for all you members. I'll try to get that working again. Sorry about that. Thank goodness everyone comes here for legal expertise and not video streaming expertise. But until tomorrow's show, I remind all of you, if you carry a gun so you're hard to kill, make sure you know the law so you're hard to convict. And until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.